Friday session of this conference. Economic and financial crime, in particular organized crime, is often committed through legal persons, and the criminal offenses included in the scope of this directive can be committed in their interest or for the benefit of such legal persons. Therefore, freezing and confiscation orders can be issued also against legal persons in accordance with national law. This is recital 4 of the directive, which fairly enough account for the multiple provision which the new directive laid down in relation to liability of legal person and the imposition of seizure and confiscation against legal person. And many provisions were provided for also under the regulation. So it is very appropriate that this conference includes a session focused on legal person. We have 3 speakers, since unfortunately Judge Oppenheimer hasn't been able to join us today. And the first speaker is Amalia Orsina, researcher in criminal law at the Faculty of Catania. Among his many publications, Amalia has written an extensive confiscation on the liability of legal person. And that is why today she's going to deliver a speech concerning preliminary remarks about the application of the EU regulation towards corporation. So please, Amalia, the floor is yours.
Many thanks, Professor Grandi. Good evening. Good evening. Yes, perfect. Good morning, everybody. I would like, first of all, to thank Professor Maugeri for giving me the opportunity to debate with such prestigious guests on a crucial topic like confiscation against legal persons. I would like to structure my brief presentation as it follows. First of all, I need to recall some supranational sources which stress the importance to tackle the infiltration of organized crime in legal economy. And in particular, I will recall the provisions of the EU regulation of 2018, which has been the focus of this project, provisions which highlight the risks which are associated with the pollution of legal economy through organized crime activities. And then after this introduction, I will report to you the main results of the Recover project in this matter. During these 2 years project, the partners were engaged in a lively debate on legal issues and practical obstacles in the implementation of the regulation, also with regard to corporations. And the debate covered, of course, also the possible solutions and the best practices to be adopted in order to strengthen the mutual trust and mutual recognition. And this work ended up in 3 kinds of indications, which I will summarize for you this morning: guidelines, reform proposals, and policy recommendations. Now let's start with the first part of my presentation by focusing some supranational sources and some provisions of the regulation. At first, I would like to mention the European Parliament resolution number 0459 of 2011 on organized crime in the EU. Where the EU Parliament states that in some member states, organized crime has infiltrated and become solidly entrenched in political circles, the public sector, and legitimate economic activities. Whereas it is conceivable that similar inroads have also been made in the rest of the European Union. Then in the resolution 0444 of 2013 on organized crime, corruption, and money laundering, the EU Parliament underlines that organized crime is increasingly becoming an economic global player with a strong business orientation, enabling it to supply different kinds of illegal and, to an increasing extent, also legal goods and services at the same time. Well, I could go further in enlisting relevant documents like these that I have just mentioned, but I prefer just highlighting that all these documents highlight mainly two facts. On one end, the ongoing and always more sophisticated evolution of organized criminal groups towards investment in legitimate and legal business with a substantial cost in terms of distortion of the free market. And on the other hand, the need for improving the law enforcement capacity in tracing and confiscating these illegal investments. Well, on the basis of these premises, the regulation considers a legal person as recipients of confiscation. In particular, the recital 15 of the preamble, together with Article 2, paragraph 1, number 10, explicitly states that the person who is affected by a freezing or confiscation order can be a natural or a legal person. Then, according to the recital 25, states that when the order is issued against a legal person, the freezing or confiscation certificate could be transmitted to the member states where the legal person is domiciled. In its turn, Article 2, paragraph 1, number 10, establishes that the confiscation order results in the final deprivation of property from a natural or a legal person. And then a very important rule is established, is provided for by Article 23, paragraph 2, where we can read that a freezing order or a confiscation order issued against a legal person shall be executed even where the executing state does not recognize the principle of liability of legal person. So it is a very important rule which facilitates the issuance of a certificate regarding a legal person to any member state. And finally, the legal person can be also a victim, as the recital 45 of the preamble affirms that the notion of victim is to be interpreted in accordance with the law of the issuing state, which should also be able to provide that a legal person could be a victim for the purpose of the regulation. Well, after saying that on the legal framework, I would like now to move to the results of the Recover project in interpreting these provisions by recalling some of the main guidelines, reform proposals, and policy recommendations that the partners of the project have elaborating during these 2 years research. Among the guidelines, a first guidelines consists of harmonizing legal standards in order to simplify international cooperation in the fight against financial crimes. In particular, the Portuguese partner highlights the need for introducing, where it is not already provided for, the liability of legal person for money laundering, along with the confiscation of the related assets. This need is recognized by some pieces of EU legislation, like the Directive 1673 of 2018, which focuses on combating money laundering. And so in compliance with this EU directive, member states should adopt legal provisions that hold legal persons accountable and enable the confiscation of their assets. Another guideline consists of widening the asset recovery scope by clarifying that also indirect profits can be targeted through extended confiscation. In particular, the Polish partner underlines the need to broaden the scope of the assets that can be addressed by confiscation, so all the proceeds, whether directly or indirectly obtained. And in this regard, I should remind that the concept of proceed, which is adopted in the directive of 2014 and now in the new directive, is a very wide, and it encompasses also indirect benefits. Another guideline consists of updating legal handbooks for practitioners, judges, prosecutors, and law enforcement agencies to reflect current challenges in enforcing freezing and confiscation orders. In particular, our Spanish partner highlights the need for replacing with an updated book the existing guide on how to issue and execute requests for enforcement of freezing orders, aligning with the Council Framework Decision of 2003. More generally, of course, the equipment of legal practitioner with the most current and comprehensive guidance on enforcing freezing orders is, of course, an essential measure in the fight against financial crimes. Moving on to the reform proposals, I can mention a reform proposal which consists of the harmonization of essential safeguards with regard to corporations. Having in mind that, according to the recital 18 of the regulation, the essential safeguards for criminal proceedings, which are set out in the Charter, should apply to proceedings in criminal matters, even if they are not criminal proceedings, but they are covered by the regulation. The reference, of course, goes to legality principle, culpability principle, in the meaning of culpability of corporation, the principle of proportionality of its punishment, and the rehabilitative education, the principle, the right to do defense, to legal assistance. So, of course, this principle need at first to be adapted to the particular artificial nature of a corporation, and then need to be harmonized among member states. Another reform proposal that I can remember comes from Spain. It was mentioned yesterday, I think, that is to say the reform proposal which consists of designating the public prosecutor authority as the single point of contact for a streamlined asset recovery process. And granting it authority to execute freezing orders in urgent cases. In particular, this proposal consists of empowering the public prosecutor to directly receive both seizure and confiscation certificates from the issuing authority. This proposal aims at centralizing the receipt and processing of the freezing certificates within the public prosecutor's office, so that the judicial system can respond more swiftly. And furthermore, the Spanish partner suggests to empower the public prosecutor's office with the execution of freezing and confiscation orders in more urgent cases. So in particular, in light of the ARO's non-judicial status within the Ministry of Justice, according to this proposal, in urgent scenarios, the public prosecutors should be preemptively granted the competence to recognize and execute freezing certificate immediately upon the receipt and registration, so that the problem, the dissipation of illicit assets can be prevented, can be avoided. And in this case, should an individual contest a freezing order recognized by the public prosecutor's office, the protocol mandates the immediate communication of the degree of recognition and execution within a maximum time frame of 24 hours to the first instance criminal court, which can either revoke or confirm the degree within the next 72 hours. Another reform proposal comes from Italy, and it consists of promoting the re-educational function of punishment of corporation. In Italy, we have the legislative decree 231 of 2001, which provides for a form of liability which is substantially criminal, even if it is formally labeled as administrative liability for the crimes committed by individuals. And the main aim of this regime is the re-education of the corporation. And in this regime, within this regime, the confiscation represents an essential prerequisite in order to pursue the re-educational function, as only by preventing the corporation from taking advantages from the crime, the preventive effectiveness of also the other afflictive sanction can be assured. Otherwise, if the corporation could take advantage from the crime, of course, it would be convenient for it to assume the risk of other sanction in light of cost-benefit analysis. In particular, in coherence with the overall re-educational aim of this decree 231, confiscation correctly gives way to the restitution of the price or the profit to the injured party and to the protection of the rights of the third parties in good faith. In this regard, in particular, Article 19 of this decree states that in case of conviction, the confiscation of the price or the profit of the crime is always ordered against the corporation, except for the part to be returned to the injured party. And this is without prejudice to rights acquired by third parties in good faith. And also Article 17 is relevant, as according to this provision, in case of the restitution of the profit, the disqualification, the disqualifying sanction can be avoided. Well, so the Italian proposal is that along the lines of this model, of this national model, the re-educational function with regard not only individuals but also corporations, and in particular the reparative function of the confiscation should be fostered at the EU level. As a matter of fact, as highlighted by the doctrine, the confiscation of the profit, in particular the confiscation by equivalent of the profit with primary restitution to the injured person, if conceived in a reparative logic, could be particular virtuous, as it would become a part of a reparative program, which is not merely vindicative, again, against the offender, but profoundly restorative in favor of the victim, in light of the idea that the crime does not pay. And furthermore, in Italy, this re-educational aim is pursued by inducing a corporation to adopt adequate compliance programs which are aimed at preventing the risk of commission of crimes by individual offender. Therefore, a greater harmonization at the EU level would be appropriate also by promoting at the EU level the remedial conducts and the adoption of these organizational models, these compliance programs in a re-educative logic. And by this way, it would be possible to fill in the gap of the supranational instruments which are in force at the moment, which, while largely imposing the adoption of effective, dissuasive and proportionate sanction in case of sanctions, in case of corporate liability, don't indicate the function to be pursued by these sanctions. Then, moving on quickly to policy recommendation for in order to not stall time to the other speakers, I can remind that just a policy recommendation, that is to say, to foster at the EU level alternative instruments which are less invasive than confiscation, but at the same time are aimed at the therapeutic management of the enterprises. In Italy, the reference goes to new alternatives to confiscation, like the judicial administration under Article 34 of the Legislative Decree number 159, and the judicial control of enterprise in Article 34 bis. These instruments, which are less invasive than the traditional ablating measures, can cut the company's ties while at the same time maximizing the chances of the survival of that business. So in a wider European perspective, the proposal of these alternative instruments to confiscation should be considered as a tool both to combat the traditional mafias, which are always increasingly looking outside the national borders, and more generally to tackle the infiltration of organized and economic crime in illegal economy. Ultimately, these instruments are very useful to set a balance between the need to repress illegality on one end, and on the other end, the safeguard of social value of enterprises. And so this proposal is ultimately aimed at guaranteeing the compliance with the proportionality, with the principle of proportionality at the EU level, in order to assure that we can target corporate crimes with the proper degree of severity. However, this topic will be covered in greater details by the other speakers, so I just stop tagging now, and I thank you very much for your attention.
Thank you, Amalia, for this very clear and straightforward intervention that not only provided us with a very clear overview on the relevant provision of EU law sources and the Italian law concerning the liability of legal entities, but also revised many of the insight and proposal put forward by the partners of your project concerning the topic on the table. And by doing so, you also established a connection between your intervention and the next one, by Annalisa Lucifera, who is a researcher in criminal law at the University of Catania. She's an expert on European supranational criminal law, having published a number of articles of many topics like the general principle of EU criminal law, crimmigration, the fight against environmental crime in Europe. And lastly, a monograph concerning the exploitation of workers, also in comparative perspective. And today, Annalisa is focusing on a preventive measure under the Italian anti-mafia code that is an alternative to confiscation, namely the judicial administration. So please, Annalisa, the floor is yours.
Thanks to Professor Grandi. And first of all, I would like to thank Professor Maugeri for inviting me to the closing conference of this interesting project. Well, to make the better use of these 20 minutes, I decided to divide my presentation into 3 parts. In the first part, I will outline the conditions and the prerequisite for applying the judicial administration. Next, I'll discuss a case where the court effectively implemented it. And finally, I'll offer a broader reflection on the trends shaping the use of the judicial administration. Well, first of all, let's try to understand when does this measure apply. As you know, this measure was introduced in 92 and now is provided by Article 34 of the Anti-Mafia Code, as Dr. Estorsina said. When does it apply? It applies when I was a problem with my slide. It applies when sorry. When there are sufficient grounds to suggest that the free exercise of economic activities, including business, is directly or indirect subject to the condition of intimidation or submission provided for in Article 416 bis of the Criminal Code. And this is the first case of the judicial administration where the business, when the enterprise is victim of organized crime. The second case is when there are sufficient grounds to suggest that the exercise of economic activities may, however, facilitate the activity of person against whom personal or asset-based preventive measure have been proposed or applied, or person subject to criminal proceedings for any of the offense listed in the Italian Criminal Code, such as mafia-type association, labor exploitation, extortion, usury, money laundering, and use of money, assets, or benefits for illicit origin. And in this case, the court order the judicial administration of assets which can be used to carry out these activities. These are the cases when judicial administration can be applied. And it is important to underline that in this case, the owner must not be considered for preventive measure. So he has not to be considered dangerous, that is suspected to be involved in criminal activity, even if in the past. Otherwise, it will be possible to apply seizure and confiscation provided by Article 20 and 24 of the Anti-Mafia Code. But also, it is important to highlight that the law does not demand the existence of actual pollution of the considered economic activity with flows of money from illegal activities of the facilitated criminal persons, since the only objective requirement for the temporary suspension is effective and conscious facilitation of such person. But what is the object of the judicial administration? Well, the object is the whole business, so not only the proceed or the instrument of crime. And what does the application of judicial administration involve? It involves that the managers are removed. So the court appoints a delegate judge and a judicial administrator who has to manage the business. The judicial administrator has to present a statement about the economic activity and the reports to the public prosecutor. This measure can be applied for a time not exceeding 1 year and may be extended for an additional 6 months with a total duration not exceeding 2 years. Well, it is evident the political criminal purpose of the measure is to turn away the organized crime and also to reclaim the business, in particular when the company is only a victim of the organized crime. So in the first case I described. And an interesting application of this measure occurred in the Uber case. And let's move to the second part of my presentation. In May 2020, the prevention measures section of the Milan court ordered the judicial administration of the company due to labor exploitation of Uber Eats delivery riders. The investigation revealed that riders were paid €3 for delivery, regardless of the day or the time, and they were often deprived of tips, creating conditions of labor exploitation. And it is interesting to underline that during the administration period, Uber Italy actively collaborated with authorities to reform its labor practice. Protocols for riders, safety and health were adopted, economic conditions were improved, and control systems were implemented to prevent further abuses. And also, at the same during the administration period, Uber Italy, that at the time of the court intervention had not implemented any compliance model, subsequently the company took steps in collaboration with the judicial administration to establish a structured and comprehensive prevention system. This system encompassed all intra-group relationship and was aimed to promoting transparency and legality in contractual relationship and in provision of food delivery service. So the Uber adopted during the judicial administration compliance model, and this led to the early revocation of the measure of the judicial administration in March 2021. And also, it's important to say that in the Uber case, there was an original application of the measure, because instead of the removal of manager as provided by Article 34, they are supported by appointed supervisor with the commitment not to manage, but to implement a number of requirements aimed to keep the enterprise of the necessary safeguards to prevent in future similar corporate conduct to those that occurred. So there was an application, a sort of tutoring, and the content of this order of the Milan Tribunal is similar to the new tool which was introduced at Article 34 bis, and the instrument is the judicial control, and Teresa Bene will explain when the judicial control apply. So it is important to stress that as we can read in the order of the Tribunal of Milan, the purpose of the measure is not repressive but preventive, aimed that is not at punishing the company who is connected to criminal association, as much as to counter the unlawful contamination and healthy enterprises, subjecting them to judicial control with the aim of removing them as quickly as possible from criminal infiltration and return them to the free market once purified of the polluting elements. So I think that there is a new approach to corporate crime, a new approach focused on therapeutic measures, designed not as we said for a repressive purpose, but with a preventive focus. And this approach that is not applied only in the Uber case, but in a lot of other proceedings, offers an alternative to traditional criminal sanctions such as seizure and confiscation, which can have detrimental effects on business operation. And this strategy allows for the contamination of economic activities while ensuring both their productive and managerial continuity. And this therapeutic function of this measure has been recognized also by the Supreme Court, that refers to a potentially alternative approach to the usual confiscation of assets. The Supreme Court said that these measures aim at rehabilitating the entity, allowing it to avoid the full or partial restriction on its activities, thereby preserving economic order and market stability. But what are the advantages of this approach? But, well, for the companies, it is an intervention in bonum partem because we know have permanent negative effects. There is no the stigmatizing effect typical associated to criminal loss action, and there is also no entry in the criminal record with all the consequences it entails. And for the prosecutor, what are the advantage? Well, it allow to overcome the challenge of identifying a focal point for criminal liability. And it allows also to have concrete results in a short time frame and also cost saving. This has been underlined in another sentence of the Supreme Court of the court says that the purpose of the new prevention measure provided for in Article 34 lies in the need to safeguard business continuity, avoiding economic losses, guaranteeing the effectiveness of management interventions, protecting the employment needs of health companies, with the aim of preventing through public support and an intervention specifically aimed at sterilizing precisely the risk of mafia infiltration within. But there are also disadvantages, and because doctrine has criticized the application of judicial administration in the Uber case. And what are the disadvantages? First of all, reduce the safeguards for the entity because there is no adversarial process. It is not possible to appeal this order because it would be possible only to appeal the confiscation of the renewal of the order. And also the risk to affect the mere victim of the mafia or organized crime. This is in the first case of application of the measure. In this complex scenario, how can a balance be achieved? It is possible to find a balance. It is difficult to find a solution. Can the application in the Uber case be considered the best practice? I think that is an very interesting solution that the Tribunal of Milano found in this case, because as I have said, there was not the removal, but a sort of tutoring. And this approach, endorsed by the Anti-Mafia Commission in 2021 report, addressed the need to respect the principle of proportionality. We should guide any form of state intervention in fundamental rights, such as the right to property and economic initiative, protected by Article 41 and 42 of the Italian Constitution, and protected also by Article 1 of the additional protocol to the European Convention. So it's evident that we are facing toward a new system of public control for entities. And this system is consistent with the trends in foreign legal system. So in conclusion, one hopes that this framework will develop in a way that balances effective oversight with respect for fundamental rights, ensuring fairness for both public interest and private entities. Thanks for your attention.
Thank you very much, Annalisa, for your very clear intervention, also enriched by a very interesting reference to the recent case concerning Uber before Uber company under the investigation before the tribunal in Milano, which clearly display the timely relevance of the topic that you have just addressed. And as a matter of fact, I like to inform our international partner that the interest of the Italian literature, especially in most recent years, is somehow shifting from the traditional topic of the preventive anti-mafia confiscation toward the other alternative preventive measure laid down in the anti-mafia code, especially those applicable on corporation, just because the public prosecutor offices are resorting more and more to this kind of measure applicable on corporation that they somehow display some advantages in the perspective of the public prosecutor in comparison with the preventive confiscation applicable on natural person. And that is why we shall now continue focusing on such measure that the anti-mafia code can be imposed on corporation with the intervention of Professor Teresa Bene, full professor of criminal procedure at the University of Naples, Federico II. Among many publications, she also focused on investigation on economic crimes, transnational judicial cooperation, and the application of patrimonial measure against corporation. And Professor Bene is now focusing on the next preventive measures under the anti-mafia code after judicial administration, namely the judicial control of enterprise in relation with the disqualification of in the Italian legal system. Thank you, Professor Bene, and the floor is yours.
Thank you, Professor Grandi. Good morning, everyone. And thank you, Professor Maugeri, for joining me today. The topic of my presentation is the forms of the public control over enterprises towards the demise of judicial control. Over the next 15 minutes, I will provide an overview of the evolving landscape of public control mechanisms that aim to counter criminal influence on enterprises and the impact these changes have had on judicial oversight. Let's get started. In recent years, we've witnessed the significant shifts in how criminal policy control economic activities to ensure their integrity. This shift is especially pronounced in combating criminal influence, particularly in mafia-dominated regions, where judicial and administrative measures are in place to prevent infiltration into legitimate enterprises. In this presentation, I will explore the purpose of public control measures, the changing role of judicial control, and how these frameworks affect companies that are close to mafia. I also discuss the growing trend toward administrative control and collaborative prevention measures. Now let's have an overview of a public control mechanism. Public control processes are designed to ensure that enterprises can operate free from criminal interference. These measures serve two purposes: to prevent the infiltration of organized crime and to preserve the economic value of the enterprise by ensuring continuity, production, and employment. The key instruments employed by judicial authorities include non-ablative surveillance, which means that they don't dismantle the business but rather oversee it to remove harmful influences. This approach allows businesses to remain operational while eliminating criminal elements. Judicial control and its evolution. One of the most important shifts we've seen is in the nature of judicial control. Traditionally, judicial administration was used to supervise companies. However, this has evolved into autonomous judicial control, where judiciary can act without being tied to a broader administrative process. This means that the courts can now implement control measures when they detect only occasional facilitation of criminal activity. By targeting incidental connections to criminal organizations rather than systemic issues, judicial control focuses on preserving the legitimate economic activity while addressing criminal concerns in a proportionate manner. Now, let's talk about case law insights. Judicial control, especially under Article 34 bis of the Anti-Mafia Code, takes two main forms. First, control requests by judicial authorities, and second, control requested by companies themselves, typically after they've been subject to anti-mafia interdiction orders. Case law has clarified that for judicial control to be applied, there must be evidence of occasional facilitation of criminal activity. This prevents automatic applications of control and ensures that each case is examined on its individual merits. However, the distinction between occasional and systemic facilitation remains a point of debate in both judicial and academic circles. Moving on, let's introduce collaborative prevention measures. Beyond judicial measures, we now see the rise of what's termed collaborative prevention. These are measures taken to remediate companies before anti-mafia interdiction are even issued. Introduced by Law Decree number 152/2021, collaborative prevention allows businesses to address potential risks of mafia infiltration early on, thereby avoiding harsher penalties or shutdowns. This is a significant development because it focuses on rehabilitation rather than punishment, aiming to strike a balance between safety, public safety, and protecting the economic rights of the business. Moving on, the role of the prefect. The prefect, an administrative authority, plays a key role in collaborative prevention. Under Article 94 bis of the Anti-Mafia Code, the prefect has the power to oversee companies that may have facilitated mafia activities on an occasional basis. If the prefect deems it necessary, they can implement oversight and preventive measures for a period of 6 to 12 months. During this time, the company has a chance to rehabilitate itself. This mechanism underscores the growing importance of administrative control as a preemptive tool for avoiding full judicial intervention. Now let's explore how these two forms of oversight interact and sometimes conflict with each other, interplay between judicial and administrative control. The relationship between judicial and administrative control over companies is complex, often leading to jurisdictional conflicts. For instance, administrative oversight by the prefect may delay or interfere with judicial control. Despite efforts to harmonize these processes, gaps remain in aligning collaborative prevention with judicial measures. Article 49 of Law Decree number 152/2021 introduced Article 94 bis to the Anti-Mafia Code, empowering the prefect to oversee companies for 6 to 12 months, aiming at rehabilitation rather than punishment. Anti-mafia interdiction is only applied in cases of serious infiltration. The balance between administrative and judicial control under Article 94 bis and 34 bis reflects a focus on collaborative prevention to stabilize companies. The legislator has implemented two corrective measures. First, under Article 34 bis, paragraph 1, the court may adopt judicial measures in place of administrative ones. Second, Article 47 of Law Decree 115/2021 amends Article 34 bis to suspend the effect of anti-mafia interdiction when judicial control is applied. This aims to streamline the collaboration between the court and the prefect, ensuring that the national anti-mafia database remains up to date. let's take a look at additional forms of public control. In addition to the Anti-Mafia Code, several laws provide public control over enterprises. Law number 199 2016 combats undeclared labor, while legislative decree number 231 of 2001 allows for judicial receivership in cases of criminal activity. These laws enable the appointment of external administrators to oversee business operations, aiming to prevent criminal disruptions to economic stability and employment. In the first case, under Article 3 of Law number 199/2016, judicial control is used instead of company seizure when criminal proceedings could impact business activity. This maintains economic stability and protects jobs. And Law number 161/2017 expanded this scope to include cases where businesses may unintentionally support criminal activity. In second case, legislative decree number 231/2001 focuses on preserving essential services and preventing harm to the community through judicial receivership. If a disqualification section threatens to halt a company's activity, the judge may appoint a commissioner to ensure continuity, provided the company serves a public or essential function. These overlapping frameworks can create confusion, as businesses may face multiple interventions. While there are similarities between these laws and the Anti-Mafia Code, legislative decree number 231 is less precise regarding the commissioner's duties, highlighting the need for clearer distinctions between preventive and punitive proceedings. To conclude, in my opinion, the forms of public control over enterprises are in evolution. While judicial control remains an important tool in combating criminal infiltration, how said Dr. Lucifera and Orsina, and we are seeing an increasing reliance on administrative controls, particularly through collaborative prevention mechanisms. This shift aims to balance the need of public safety with the protection of legitimate business, but it also raises questions about the efficacy and fairness of the system. Looking ahead, it's clear that further regulatory refinement is needed to ensure that business can operate free from criminal influence while avoiding unnecessary burdens from overlapping control mechanisms. Thank you for your attention.
Thank you, Professor Bene, for your very interesting intervention that also very clearly displayed the relationship and the differences between judicial administration and judicial control, which can be somehow tricky, not only for our international partners, but is also worth revising for us, at least for myself. And so I would like to thank the speakers for the clarity and also for being perfectly in time and respectful of the schedule of this session. Since unfortunately Judge Oppenmeyer could not join us today, I suppose we have some more time before the break for some. Okay. Okay, so because okay. So we are now filling the gap of time left by the fact that Judge Oppenmeyer could not join us in this session. And I'm now leaving the floor to Dr. Anastasio, who's delivering a speech on the best practices and reform proposal resulting from the project Recover. Facciamo prima di battere. Ok. Va bene, perfetto. So while Dr. Anastasio is getting ready with this presentation, we have time for some questions, for some requests for clarification from the previous speakers. Are there any questions? Yes, please. Would you like to use the microphone? Because otherwise they cannot. Is there a mobile microphone or not? Okay.
I understood that the prefects have some powers, really powerful, I want to say, to administrate the legal persons here in Italy. So my question is, prefects are appointed, political appointed here in Italy, because it's a very strong power. I don't think Romania can do it because as a political system, namely appointed as a political power to administrate a legal person, which is a private activity, I don't saw it very well in our system, but this is why I have this question. And what was the reason to do such a power to the prefect?
Thank you very much for the question. Is very interesting. I don't know who wants to take. Elisa? Yes.
It's possible, but however, is a point that has been very criticized because we have a strong public intervention in the private economy. And I spoke with a lawyer who defended a company subjected to judicial administration, and he stressed this aspect because the management of the company was completely replaced. So yes, in Italy is possible, but is a controversial and criticized profile. I don't know if Professor Maugeri says. Yes. Yes. Judicial. Bond. Guarantee.
think Professor Vogt raised his hand. Yes. Yes. Okay. So just wait, maybe we.
So I was just wondering who pays for the administration of companies, because if state enables facilitate operation of its company, and then perhaps the state. I'm just curious. Billion.
Yes, that's a very.
The
that's-
fact that sometimes this cost for the business for the companies is too much, but in the end it is better to pay the judicial administrator in order to carry on the business. Otherwise, you know, it's confiscation. So it is a bad. There are some rule. Some years ago, there was also a big case, a judicial case, because this judicial administrator had too many cases, because he was a very big, very good administrator. Now there is a rule that the judicial administrator can't have more than 3 cases, so 3 enterprises, 3 companies carry on to manage. So, but in any case, it is a cost for the company.
Yeah.
So,
But
And that's a very sensitive issue.
what
because-
is sorry, I would only one. It was important for me to stress this alternative measure. I invite my colleague to speak about this subject, and I invited also the Judge Opmeyer to speak about the deferred prosecution agreements, because the idea can be for companies, no, for economic activity, interesting it is to have an alternative to confiscation, because in the practice in Italy, even if we have a very complete law about the protection of third parties, about the management of the companies when the company is frozen, but in the end of the procedure, the company is completely folded, is down, is not able to stay on the market, because it is difficult, no? To this solution, we have good results, but what is important is that there is a company which is safe in some way and which is able to stay on the market in legality, no? In legal condition. When the company is only in the market only because it is supported by mafia, or because it works in illegal condition, it is not possible to save, no? But for me it's important to have this alternative. I hope that can be a good alternative also in European vision. Because in the practice, many prosecutors, when I speak about this subject, about confiscation against legal person, in other countries, the prosecutor there isn't a good practice, no, against companies, because it is difficult, no, to freeze and confiscate a company. Also for the economic consequences, no, for the employees, so on.
When infiltration is occasional, for example, judicial control. It's a important point, occasional infiltration. So,
also is important for the workers, because with confiscation, as I said, and as Professor Nogeri said, you have detrimental effects on the company, and especially in the case of labor exploitation, is the problem of employment of workers. So with this measure, you can balance the different needs. So yes, for the enterprise is a cost, but I think that for the market in the complex and from the workers is a minor cost that the confiscation measure.
And not only the situation where confiscation is imposed and then revoked, but also after freezing. Also, the simple freezing can really put the company out of the market. So, and losing their productive capacity or the competitive strength on the market. So sometimes the judicial control or administration is a good solution also for the company. But what I would like, if there are no more questions, I just have one. Yes? Okay. Because they don't.
Very brief. Wondering what happened to the company after that. Understand. Maximum bill to. What will happen later? How that company will return to the market? How can directly not go any control of it?
We have an interesting application because the measure was revoked before the period provided for it, because the enterprise returns to the compliance, and the aims of these measures is the legal compliance of the enterprise. So we can see parallelism with the educational function of the decree 231, as Amalia Orsina explained, because the aim of the legislator is to return of the enterprise to legal compliance. And in this case, but yes, if this aim is not getted, you can extend the measure, but for a maximum period of 2 years.
New compliance programs on the problem is solved. Okay, the measure ended. If it is possible to confiscate, because if during the judicial administration the judicial administrator discovers other elements which support the legal origin of the property of the company, is possible to apply the confiscation. Yes. No, but the idea is that we don't have to think that the company is of a criminal. It's a company which has committed a crime, or has committed a crime, not necessary, but in that case has committed a crime, but is involved or is in some way is infiltrated. For example, one of the first cases, TNT case, was the Dutch company of dealing, and in that case, in Italy, this activity of the Dutch company was organized by the 'Ndrangheta, no? By which the support of the 'Ndrangheta. So the solution was to change some manager in the Italian company, because the TNT, the Dutch company, hasn't interest to have a relationship with 'Ndrangheta. No, so cut this relationship with 'Ndrangheta, changing the managers. The problem was solved. Without is not the idea that come back to the criminals. No, the problem is to cut the contact, the relationship, or to adopt new compliance programs in order to prevent for the future the risk to commit crime. Because in the Uber case, in the end, the company was committing the crime of exploitation of workers, and it
And yes, and this experience, I think, highlights the extrema ratio of confiscation, because if it's possible, okay, we try to get the legal compliance with these measures, but after 2 years, if it was not possible, we apply confiscation like extrema ratio measure, and like criminal law is extrema ratio.
yes, we have also the
Yeah.
legal
Yes.
our system. So, but in this
Finiscono.
moment, the judge, the prosecutor of Milan, not of Catania, the prosecutor where there is in Italy the economy that is in the north of Italy, they prefer to apply this measure. Yeah, because it is better also in order to to guarantee that the company carry on in its activity when the company in the end is safe.
Yeah.
Okay, I think we can be very satisfied that the debate of this session is very lively. But before leaving the floor to Dr. Anastasio, I have, if there are any more questions, because otherwise I would like to put forward maybe the last question to Annalisa. In my previous very brief comment on your speech, I mentioned the fact that public prosecutors are resorting more and more to the alternative measure of the anti-mafia code. So, so what are the advantages in the perspective of the public accusation in comparison with the other instruments available, for instance, under the legislative decree on the legal liability of the legal entity 231 of 2001?
Thanks for your question, Ciro, because for time reasons, I couldn't deepen this profile in my presentation, but I think that is very interesting, because the most problematic aspect of the Uber case, as Professor Maugeri said, was that judicial administration was applied in cases where the company, that is where Uber, knows the labor exploitation conduct committed by the small company who directly manage the riders. So it would have been possible in this case to establish organizational culpability and apply the legislative decree 231. Okay, so it for this legal literature has criticized this approach of the Tribunal of Milan, and why the prosecutor preferred this approach, for the reason I said, for time, cost, and especially because it is very difficult in a globalized economy to establish the organizational culpability, because labor exploitation were committed in one company, in a small company, and Uber was another company at al vertice, on the top of the supply chain. And so I think that for a time, cost, for all the reason I said.
Right, clear, right, clear. Thank you. So, so before the break, I think we can anticipate the speech by Dr. Matteo Anastasio, currently attached to the Transcrime Center of Research in Milan, and is going to deliver a speech on the best practices and reform proposal resulting from the project Recover. So just to sum up the result, the outputs of this project. So please.
Yes, thank you very much. I believe you can hear me. Yes. And yes, my focus will be precisely on VP5 and on asset recovery offices, management of frozen and confiscated assets, so on the 5th VP of the project. Before going to policy recommendations, I would like to outline my presentation, which will be divided into 3 parts. The first one will detail a bit the data that we have thanks to the Italian hero, and namely Colonel Ribaudo, that has provided us with very useful information related to the activity of the Italian areas in Europe, and namely on the activities of the Italian aero. And then we will go into policy recommendations related to the VP5 and with a special focus on the new directive. So to begin with, as I was saying, our structures and activity. Here we have the outline of the 3 different types on the first graph of areas, which, as you know, may be judicial, police areas, or multidisciplinary. We see that in Europe, the majority of areas are police ones, so are within the police mechanism, while there's the second category is a multidisciplinary one, so police and judicial ones, while the third category is judicial areas, so areas that deal quite exclusively with mutual recognition requests. The average staff is quite high related to multidisciplinary areas, while quite lower related to judicial and police areas. Then we have the numbers related to whether areas are a central point for mutual legal assistance requests related to asset recovery. We see that for judicial areas, this is true in the vast majority of cases, while this is not entirely true for multidisciplinary or police. And we have the impression that police areas remain attached to police structure and police mechanisms most of the times. And this is also related with a different sensitivity, let's say, in the collection of data, of course, in the sense that the areas that collect the data are usually judicial ones, but also multidisciplinary, and police to a lesser extent. This is the detail related to the Italian aero and where requests destined to the Italian aero come from. So we see that the vast majority of requests come from foreign areas. So the majority of the activity of the at least Italian aero is dedicated to the international cooperation, and then we have another lower level of requests coming from internal departments within aero. So this is good in a way that it allows us to say that errors are quite on the international side in a way, but at the same time, we don't have information about the output of those requests and what they were about and what were their outputs. So we can't outline better than this what is the functioning and how it is going. Here is the detail about the countries of origin of foreign requests in a span of 4 years. So we can see that there's they come mainly, at least for Italy, from France, Romania, and Netherlands, and their number tend to decrease in other in the second part of the graph. This is the detail about the asset frozen abroad by Italy by country. Again, the data come from the Italian aero. Here we see that Germany has probably for some specific operations. Maybe we can also, I don't know if this has something to do with the presence of 'Ndrangheta in Germany, which is quite high, we know, but there's a clear outlier for 2023 for Germany, but the number are again quite low. Here we have the typology of assets, and we see that the vast majority of assets are movable assets, contrary to, in terms of values, contrary to national domains where the most values is on immovable assets usually, and that it tends to decrease from the high level of 2021. And this is the level we were talking about, asset frozen. These are the asset confiscated, where the numbers are lower. Again, the time span is 4 years, and here are the numbers. So the maximum in Malta with 6 assets, which again is in a span of 4 years. It means 1.5 per year, which is quite low, again, in terms of number. And here we have the values. Again, movable assets are usually the center of this asset recovery activity instead of real estate, which is the center of the national law enforcement activity on the assets, except for 2020, which was an anomalous years for clear reasons. Then, what I was saying, yeah, I proceed with the policy recommendations of this VP that we have drafted together with the partners in the course of the VP. I've organized thematically them into different themes and subjects. So the first ones are enhancing capacity resources of EROS and EMOS. You see in brackets the name of the state from where we have tried to derive the recommendations, and we have also have a confrontation with all the partners about the recommendations. So first of all, increase the capacity of AROS, especially in relation to the new competencies that the directive allows them to recognize to them. So in terms, of course, of staffing, of resource, and alongside with an adequate selection of competent personnel, and at the same time help their operation providing clear documentation and instruction in the sense that AROS must be guided in all the process of mutual recognition and application of the regulation. Then we have specialized competencies for asset management. So we move on to asset management. So develop a wider skills and capabilities to manage the diverse range of assets, because we're talking about vehicles, arts, jewelry, so different kinds of assets, again, with capacity building and training and the use of external experts also to evaluate the amount and value of assets accompanied by specific resources for police training and on management. On the second block, improving information exchange and communication. So strengthen, of course, the exchange information using both established and established mainly channels such as Siena, the Carrion Network, and other forms of platforms. Help disseminating best practices through our AROS network. Again, insist on a clear outline of all the procedural step and information about between authorities about all the phases of the recognition of requests. We know that sometimes among different AROS, the destiny of the good, the destiny in a way of the procedure is lost, and it's good to maintain this channel of communication between different law enforcement authorities that try to confiscate goods and allow and pay attention to the specificity in requests where addressing requests to AROS. Then we have, again, regional cooperation networks that could allow for a better regional cooperation for better law enforcement, and the coordination between legal instruments, and namely EU-wide instruments such as the European Investigation Order that allows for a good coordination between member states, and these, of course, have to translate in a good law enforcement and confiscation measures, and the cooperation with the EPPO recently established that could help all the asset recovery process. Then we have the recommendation on establishing central contact point for streamlining the cooperation between AROS and AMOS, allowing for the information sharing, the widest possible information sharing among AROS in a way that national authorities do not prevent the information they have to be shared, and public reporting and transparency. So maintain accessible statistics and information about how the enforcement goes. Again, on information and asset tracing management, provide for clear and updated beneficial information, ownership, taking into account also hidden links through strawman and shell companies, and translating all this information in national databases, and ensure for regular asset evaluation. This is for the side of asset management, also through the use of external experts in order to have a clear evaluation of assets. Consider also the establishment of auction portals, online auction portals, in order to also with the COVID pandemic, this was a recommendation related also to COVID pandemic, but we believe that this may help in giving the widest notoriety and about the possibility to acquire assets also for the normal people in a way, and you ensure, of course, external independent audits. So true again for the AMOS operations. Then we have the harmonization of legal frameworks related in particular to asset restitution and compensation. We see a lack of harmonization in this domain mainly. So for victim compensation and a regular legislative review and monitoring of harmonization efforts among member states. And I'm going I'm going more faster because we are I'm going quite long, but promoting social use of confiscated assets and victim supports. So for the allocation of proceeds for the public and social use of assets in the way of simplifying procedures and get this done quickly in a sense, and also victim compensation processes, again, as I was saying, in terms of both harmonization and concrete processes, address the issues in compensation or restitution cases that mostly in cross-border cases have many shortcomings, improve victim support services, and again, insist on the public awareness campaigns and digital platforms. Very briefly on the new directive, because we have collected also some observation and comments by law enforcement authorities on the new directive. We have some positive ones. In general, there's a shared feeling that with the directive, the activity of AROs could be enhanced in a way and could profit from this new legislative framework in terms of time efficiencies and, of course, inter-ARO cooperation and increased role and visibility, and in terms of effectiveness and speed of law enforcement. Then we have some warnings related to some specific aspects, namely Article 6 and 7, related to the increased access to information that is expected to improve the tracing criminal money flows, and then Article 9 that allows to be the information gathered by AROs to be used directly as evidence, which is considered a good thing, a good step forward. Challenges and limitation. We have some challenges related to urgent seizures. The time of the requirement of rapid response, in particular 8 hours for urgent requests could be seen as quite challenging. Again, we have challenges with short time limits for information access, namely in relation to Article 10, because there are not specific rules on AROS compensation resources, so member states may have difficulties in complying with this regulation, and Article 11. So again, the time limit of 7 working days may not be adequate or may be quite strict for the procedures. Of course, given the wider role of AROs, there should be sometimes we should address the staff issues and resources issues that are given to them in terms, of course, of again resources and staffing. As regards asset management and social reuse, there are quite good news probably, or at least the directive may have good effects because it allows for more flexibility and a better established framework, and it could be a good moment and opportunity for improving the social use and asset management processes in all member states. So this is all. Thank you for your attention.
Thank you, Matteo, for being so quick in summarizing so many results of the project, and I think we can all congratulate with the partners and the management committee of this project for so many brilliant results as outcome. So I think we can close now the session and we take a break, and we'll be back in half an hour, maybe. Yeah, a bit less, 20 minutes. Okay, thank you very much.